To keep yourself updated, subscribe to IndigoLearn and click the bell icon and download our app OneFin to start learning on the go.
Now that we have understood what is corresponding law, let's now move on and understand a very interesting topic, and that is offences of cross-border implications. Let's understand this with help of few practical examples, few situations which have actually happened. So let's go back to the case of Vijay Mallya. If you remember, when we started the act, we had referred to some story of Vijay Mallya wherein we understood that Mr. Mallya had taken loans of over 9,000 crores from different banks in the country, and he invested this money in different shell companies in other countries, and he did not utilize the money properly. So he did a fraud. And what happened was, Mr. Mallya, when he was asked to make the payment, he was not in a position to make the payment. And also what Mr. Mallya did was, he was not disclosing the details of his assets, he was not disclosing any information, and he was also disposing of the assets which he had in order to defeat the purpose of the proceedings. That is, he did not want to get caught, and as a consequence of which he started disposing of the assets as well, till the time the attachment of assets did not happen. So he was very secretive. He did not disclose any details of any assets, and he also started disposing of the assets so that no recovery happens when the proceedings are going on. And we also know in the year 2016, Mr. Mallya fled to the UK. So he's gone to London. He is in London till now. He's not been extradited to India. We'll talk of extradition in some time when we move on to the next topic. But here what happened, Mr. Mallya, he committed a fraud here in India, and he fled away with the proceeds of crime, or rather the money which he made out of the fraud, to some other country. So what has happened? The crime was conducted here in India, but the proceeds of crime were transferred to some other country outside India. So the conduct of crime or the conduct of offence has happened in India, and the proceeds of crime were transferred outside India. Similar thing happened in the case of Nirav Modi. So he also was involved in PNB fraud, and he fled away to UK. So there are countries wherein these people actually flee. Now, if you know, in taxation we usually talk of Mauritius. Mauritius was previously a tax haven. It is not a tax haven any longer because of the new rules and regulations which have been made there in that country, and it was a favorite place to structure any tax transaction to evade any taxes here in India. But now some changes have been made in the rules, as a result of which Mauritius is no longer a tax haven country. But yes, current favorite country of any offenders is Bermuda, because it is a tax haven right now. Bermuda is the most utilized, or I would say a tax haven country presently, wherein people go and structure their transactions. So what happened in Mallya's case? He fled to the UK. Now, does it mean now UK government cannot send him back to India? They can send him back to India, but there are some procedures which have to be followed. Now, when Mr. Mallya fled to the UK, he also took the money along with him. Did he keep the money here in India? No, the money was not here in India. He fled to the UK, and there he already has money. He is living like a free citizen there in London. He is not in jail. He is living like a free citizen in London. So what happened here? Crime was conducted in India. The offence was conducted in India, and the proceeds were transferred to some place outside India. Same happened in the case of Nirav Modi. Let's take another example. Now what is happening, there is a person, Mr. Rajiv, and Mr. Rajiv resides in the US. Now in the US, he has made a lot of money by selling drugs. So by selling cocaine, Mr. Rajiv has made a lot of money there in the US. Now this is a scheduled offence, para 2, part A, it is a scheduled offence. And now what Mr. Rajiv does is, he somehow transfers all these proceeds of crime to India and flees away to India. In the first situation, we understood the crime happened in India and the proceeds of crime were transferred outside India. In the second situation, we have seen we have understood that the crime happened outside India. The conduct of offence has happened outside India, but the proceeds were transferred here in India. So both these offences are offences having cross-border implications. Why do we say these are offences having cross-border implications? Because here there are two nations involved. Two countries are involved in both these type of offences, wherein the offence is being conducted in one country and the proceeds of crime are being transferred to some other country, as a result of which both the countries get involved and they together try to solve these money laundering cases. Let's now look at the meaning of the term offences of cross-border implications. Offences of cross-border implication means any conduct by a person at a place outside India which constitutes an offence at that place. So it is an offence in that country as well, in that at the place as well where the offence is being committed, and which would have constituted an offence specified in Part A, Part B or Part C of the schedule, that is the scheduled offences, had it been committed in India, and if such person transfers in any manner the proceeds of such conduct or part thereof to India. What is the first point talking of? It says the conduct of offence has happened outside India. And this offence which is being conducted is an offence as per the laws of that country. And if it had happened in India, then it would have been an offence as per Part A, Part B or Part C of the schedule which have been prescribed. So, an offence has been conducted which is an offence as per the laws of that country in which the offence has been committed, and would have been an offence, would have been a scheduled offence if it had been conducted in India as well. And the proceeds of this offence have been transferred in India. So, what is happening here in the first situation? Conduct of offence has happened outside India, but the proceeds have been transferred in India. So, the first point talks of if any offence has been committed outside India, in any country outside India, and the proceeds have been transferred in India, then that will be referred to as an offence of cross-border implication. Now, let's look at the second point. The second point states, any offence specified in Part A, Part B or Part C of the schedule which has been committed in India and the proceeds of crime or part thereof have been transferred to a place outside India, or any attempt. So here, even if an attempt to transfer has been made, it will be referred to as an offence of cross-border implication. Or any attempt has been made to transfer the proceeds of crime or part thereof from India to a place outside India. So what does the second point say? The second point states the offence has happened in India. The offence has been committed in India and the proceeds of crime are being transferred outside India. And it is not only talking of absolute transfer, but also if an attempt to transfer has been made, it will be referred to as a cross-border offence. So, if an offence has been committed under the Part A, Part B or Part C of the schedule and the proceeds of crime of such offence are being transferred to any place outside India, then in that situation, such offence will also be referred to as an offence of cross-border implication. Let's have a look at the explanation. The explanation says, nothing contained in this clause shall adversely affect any investigation, inquiry, trial or proceedings before any authority in respect of offences specified in Part A or Part B of the schedule to the Act before the commencement of Prevention of Money Laundering Amendment Act 2009. So this explanation basically says that if an investigation is going on with respect to that person under any offence of Part A or Part B, then this section, just because an offence of cross-border implication has been done, this offence should not bring a halt or should not interrupt with the investigation which is already going on. So the explanation basically says that any investigation shall continue. Now, if you look at the explanation is only talking of offence under Part A and or Part B. Why not Part C? Because when we talk of Part C itself is a cross-border implication, offence of cross-border implication, and that is the reason why it has not been included under the explanation. So the explanation only wants to state that if any investigation, inquiry or trial or any proceedings are going on with respect to that person for any offence which he has committed under Part A or Part B, then just because a cross-border offence has been committed, it should not bring a halt or it should not interrupt with the proceedings which are already going on. So any investigation which is going on, it shall continue. It should not be put to an end or it should not be stopped midway. Now, if we compare Part 1 and Part 2 of the definition of offences of cross-border implication, Part 1 talks of conduct of offence happening outside India and the proceeds being remitted to India. Whereas Part 2 talks of conduct of offence in India and the proceeds being remitted outside India or an attempt to remit these proceedings outside India, these proceeds outside India has been made. So there's a huge difference in both these points. When we are talking of an offence which was committed outside India and the proceeds were remitted to India, the point of attempt to remit is missing here in the first part. The first part of the definition clearly states that the offence has been committed outside India, would have been an offence if it had been committed in India as well, and the proceeds of such offence have been transferred to India. But it nowhere uses the word attempt, which means, say a question comes to you in exam wherein a person has committed an offence outside India and he made an attempt to transfer the proceeds to India but was not successful in it. I repeat, the offence was committed outside India, but when transferring the proceeds to India, the person was not successful in transferring the proceeds to India, which means he made an attempt, but this attempt was not successful, which means ultimately the proceeds of crime were not transferred to India. Is this an offence of cross-border implication? What should your answer be? The answer is definitely no, it is not a cross-border implication. Why is that so? Because an attempt was made to transfer the proceedings to India, but it was not successful. And the definition, the meaning of the term offence of cross-border implication clearly specifies that whenever an offence has been committed outside India and the proceeds have been transferred to India, have been remitted to India, only then we will refer to it as an offence of cross-border implication. So here in this situation where the person made an attempt but was not successful in remitting the proceeds to India, then in that situation it will not be referred to as an offence of cross-border implication. But yes, if the case would have been vice versa, that is, the offence was committed in India and this person makes an attempt to transfer the proceeds to a place outside India but fails to do so. But here an attempt is sufficient to refer to that offence as an offence having cross-border implication. So one very major difference in both point 1 and point 2, point 1 talks of actual remittance, and if remittance has happened then it is an offence of cross-border implication. But point 2 talks of either actual remittance or any attempt made to transfer the proceeds of such crime. So with this we have now understood what are the offences of cross-border implication. Very simple. Conduct outside India, proceeds transferred to India. Conduct in India, where proceeds are transferred to some place outside India or an attempt has been made to transfer the proceeds of crime to some place outside India. And nothing in this section, that is, these cross-border offences shall not have any impact on any investigation, inquiry, trial or any proceedings which are already going on. The investigation shall continue. Let's now understand the meaning of the term contracting state. What is a contracting state? You might have heard this word, or you might have come across this word contracting state in taxation as well, under tax treaties. So whenever you read tax treaties, the name of the country is not mentioned in the tax treaties. It is usually the term used for both the countries is contracting state and the other contracting state. Whenever you read a tax treaty, the words used in the tax treaty are contracting states, which refer to the countries who are entering into the arrangement. So similarly here, when we are talking of a contracting state means any other country with whom some arrangement has been made between the government of India and the government of that other country. So when we are talking of money laundering offences, there are several treaties which India has made with different countries. India has made treaties with UK, USA, European countries. There's a treaty with Portugal as well. So different treaties have been made by India with different countries with respect to offences under money laundering as well. Now these treaties could be these treaties are extradition treaties, wherein the offenders or the accused person, he takes shelter in some other country. For example, Vijay Mallya, Nirav Modi, they have fled to some other countries and they are staying there, and now India wants to bring them back to India, and that's where these treaties work, wherein both the countries, they enter into an agreement as to what should be the process of extradition, and apart from it, how the offences shall be tried and what are the other rules and regulations which have to be followed by both the countries in case of any cross-border offences. So when we refer to this word contracting state, we are referring to any other country with which an agreement has been made by the central government with the government of that other country with respect to the government of that other country. So contracting state is nothing but any other country with which an arrangement has been made. Arrangement basically means agreement. Prevention of money laundering rules and regulations which have been made in India are very stringent, and it is very stringent among the different countries, among the other countries of the world as well. The rules and regulations which have been made by India are the most stringent ones. And there are several treaties which have been made between India and other countries as well in order to prevent these money laundering offences, and also how they are going to deal if any money laundering offence has happened. So if it happens between two countries. So usually what happens, a person who has done a crime in one country, he'll definitely flee to some other country to get relieved from the punishment in this country. Vijay Mallya, Nirav Modi, why do you think they fled to the UK? The reason is simple, so that the Indian authorities, they do not have a say there, and they cannot catch hold of these people there in United Kingdom. And that is the reason why these people have fled there. Now Indian authorities, they cannot directly go and capture these people they cannot directly go and arrest these people from these countries. As a result of which, they'll first have to contact the authorities of that other country. Now that other country has its own procedure. Unless and until their own procedure is completed, they'll not send this person, or they'll not surrender this person to India. So India has made an extradition request in order to release Vijay Mallya, to surrender that person here in India, but it has not yet happened. Now why is that so? Because the laws in London, they give Vijay Mallya a right to make an appeal. So he has been making appeals, and he was also not present for hearings of the cases, as a result of which the extradition has not yet happened. Yes, an extradition order was passed by that other country, but the extradition is still impending because of some confidential legal proceedings which are still going on which involves Vijay Mallya there, and that is the reason why the extradition is still pending. And when Mr. Narendra Modi, he became the Prime Minister, he also stated that we'll bring back all these economic offenders back to India and we'll punish them here. So this is one claim which was made by the Prime Minister when and he stated that we'll bring all of them here in India and will punish them. It has not yet happened, but the process is still on, and the same happened in the case of Nirav Modi. He fled to the UK and there he is in a prison there right now. What claims he made, or what claims his advocate there has made for against the extradition request which was made by India, is that he states that his mental state is not well and he is in a suicidal state, and if he is extradited to India then he would commit suicide. So that was the claim which was made by Mr. Nirav Modi there when hearing was happening in the courts of that other country. So the advocate basically stated that that his mental state is not good and he is in a suicidal state, as a result of which if he is extradited to India he may commit suicide, and as a result of which extradition order has not been passed to extradite Mr. Nirav Modi back to India yet. Request has been made, but his extradition is still pending, and his extradition is still pending. And there are several other cases like this wherein people have fled to other countries, and when people flee to other countries, that's where the treaties play a role. Now when treaties are made between countries, between India and UK or between India and USA, they'll have to follow the procedures which they have mentioned in the treaty. They cannot go against the agreement which is being made between them. So it is an agreement between two countries and they'll have to follow the agreement which is being made between them for taking any further actions. So when we are referring to the term contracting state, a contracting state is basically some other country with which the government of India has any agreement or has any arrangement. Let's have a look at the meaning of contracting state. Contracting state means any country or place outside India in respect of which arrangements have been made by the central government with the government of such country through a treaty or otherwise. So what is a contracting state? It is any country or place outside India wherein an arrangement is nothing but an agreement, wherein an agreement has been made between whom? Between the government of both the countries and such an agreement is made through a treaty. Treaty is nothing but an arrangement or an agreement which is made between two countries. So what is a contracting state? Any country or place outside India with whom an agreement or arrangement has been made by the central government with the government of that other country by way of a treaty. So that is a contracting state. And what are a few examples of where treaty has been made? Which are the countries with whom India has made treaties? So India has treaties with England, USA, other European countries. There are two more small terms, the meaning of which we'll understand. The first one is identifying and the other one is tracing. Let's have a look at the meaning of these two terms. Identifying includes establishment of a proof that the property was derived from or used in commission of an offence under section 3. So identifying basically means establishing proof or finalizing that the property which is being derived has been derived because of some money laundering offence. And what does tracing mean? Tracing means determining the nature, source, disposition, movement, title or ownership of the property. So tracing is basically, you might have watched these TV series CID wherein they trace the culprit, they try and find who is the actual culprit and they take a clue from different things which have happened. So similarly, tracing here is nothing but determining what is the nature, what is the way in which the property was disposed of, how the property was transferred. So tracing, keeping a track of what is happening with the property. So that means tracing. Let's now start with section 56, which talks of agreements with foreign countries. So we've understood what is a contracting state. So it is a foreign country with whom an agreement has been made. Now talking of the agreement between foreign countries or agreements made with foreign countries. What are these agreements for and what are the things which are stated in these agreements? Now whenever an agreement is made with some other country, that agreement is for some specific purposes. Now when a tax treaty is made, a tax treaty is also with specific purpose. We want to determine where should a particular income be taxed to avoid double taxation, and also to identify where a particular income shall be taxed. Tax treaties are made, wherein is it the state of residence or it is the source which will, whether it is the state of residence or the state of source which will have the right to tax on a particular income. So similarly, when an agreement is made between India and some other country under this act, so if there is any agreement which is made with a foreign country, what is the purpose with which the agreement is made? Now there are three purposes with which an agreement is made between the central government and the government of any foreign country. Now what are the purposes with which the agreement is made? The first purpose is to enforce the provisions of this act, that is to enforce the provisions of the Prevention of Money Laundering Act. So if an offence has been committed by a person and he has fled to some other country and India wants to enforce the provisions of this act against that other person, then that other country should also help India in carrying out the proceedings or in investigating the case of that other person. So the first intention behind making an agreement is to enforce the provisions of this act. Now apart from enforcing provisions, one very important purpose with which an agreement is made with any other country is for exchange of information. So link this with your tax information exchange agreements. Information exchange agreements are made between two countries wherein they exchange information about the income of a person, about the taxes paid in different countries. Similarly, here as well, whenever any money laundering offence has been committed by any person and the government of India wants to get some information about that person from some other country, the other country has to share the information with the government of India. So whenever an agreement is made, it is not only for enforcing the provisions of this act but also for exchange of information. Now exchange of information is again subject to certain conditions and subject to certain terms and conditions. Now one country will not share every detail or every information with the other country, but yes, there are certain specifications as to which type of information shall be shared, in which situation the information will be shared. Everything is noted down, everything is in writing. So the first purpose is enforcing the provisions of this act. The second purpose is exchange of information. The third and a very important reason with which the agreement is made with a foreign country is for the purpose of investigation of the offences which have been committed under this act. So first one was enforcing the provisions. Second one was exchange of information between the nations, and the third one is to carry out investigations with respect to any offence which has been committed. So both the countries, they enter into agreements wherein they agree to allow the other country to enforce its provision, also to exchange information with the other country, and also carry out investigation with respect to any offences which have been committed under this act. Now whenever two countries are entering into any tax treaties, they will not go against the laws which are in existence in their own country. Say for example, there is a country with whom India has entered into an agreement, and the laws of that country state that no capital punishment shall be given to any person, whosoever it may be, whatever type of offence he has done, no capital punishment shall be given to him. Now this country has entered into an agreement with India, and now this country says, we will do everything, we will enforce the provisions of your act, we will also exchange information, we will also allow you to carry out investigations, but you should also take care that our laws are not breached. So whenever agreements are made between countries, both the countries will not want their laws to be breached or their laws to be overruled. So whenever agreements are made, there are certain terms and conditions which are attached to the agreements which are made between the countries, and those terms and conditions shall be abided by both the countries. Now that you have made an extradition request, we will surrender this person to you, but make sure that you are not giving him any capital punishment. So here India will also have to abide by the laws of that other country, because a treaty has been made, an agreement has been made between the other country and India, and the laws of both the countries shall be given due respect to whenever any agreement is made between them. So when talking of agreements between countries, there are three main purposes for the agreement which is made between countries. It is for enforcing the provisions of this act, it is for the purpose of exchange of any information, and for investigation of offences which have been committed. And all these agreements shall be subject to certain terms and conditions or exceptions, and these terms and conditions, exceptions shall be notified by the central government in the official gazette. So this was with respect to agreement between the countries. So what does section 56 talk of? It talks of agreement between foreign countries or agreement with foreign countries. The central government may enter into an agreement with the government of country outside India for, so what is the purpose with which the agreement will be entered? It is for enforcing the provisions of the act, that is enforcing the provisions of which act? PMLA. And apart from this, for exchange of information for prevention of any offence under this act or under the corresponding law in force in that country. So they'll exchange information with each other so that if they have any doubt, if they have any suspicion, they can prevent an offence from happening. They can prevent an offence under this act or any other corresponding law in that country from taking place. So when they have doubt, they can exchange information and they can prevent such offence from taking place. Or investigation of cases relating to any offence under this act. So enforcing provisions, exchanging information and investigation into the offences which have been committed. And may by notification in the official gazette make such provisions as may be necessary for implementing the agreement. So by notification in the official gazette, they may notify certain provisions which would be necessary for implementation of the agreement. So this basically means that if any changes have to be made or any terms and conditions have to be mentioned, then it has to be clearly mentioned by a notification in the official gazette. So what is the purpose with which an agreement with foreign country is made? It is made with an intention to enforce the provision, with an intention to exchange information, and with an intention to carry on any investigation. The second point states, the central government may by notification in official gazette direct that application of this chapter in relation to a contracting state with which reciprocal arrangements have been made. Reciprocal arrangements mean what? Wherein agreements have been made between countries to help out each other. So reciprocal arrangements are basically agreements made between countries wherein they help each other. So like I've said, ek haath de, ek haath le. So we'll abide by your rules, you abide by our rules, and let's find a way to help each other out. So that's reciprocal arrangement. Reciprocal arrangements have been made shall be subject to such conditions, exceptions or qualifications as are specified in the notification. So as we've already understood that the agreements which are made between countries may be subject to certain terms and conditions. So all those terms and conditions shall also be specified in a notification which is made by the central government in the official gazette. So what does section 46 talk of? First we have understood what is the purpose with which an agreement is made. And once an agreement is made, for the purpose of application of the agreement, if there are certain terms and conditions, certain qualifications, then all of those terms and conditions, qualifications shall be stated in a notification which is made by the central government in the official gazette. Now, after understanding that there are agreements between countries to make make enforcement of provisions and investigations smoother, and also exchange of information easier between nations. A question would come up in your mind that what is the reason Vijay Mallya and Nirav Modi and people like that, people who have been declared economic offenders, they've not been surrendered to the country yet, in spite of extradition requests being made with these other countries. So let's talk of Mr. Mallya's case. Now, an extradition order was passed by the UK government in the year 2019. So in the year 2019, an extradition order was passed that Mr. Mallya shall now be surrendered to India. But Mr. Mallya filed an appeal against this extradition order in a higher court in that other country. So in the UK, it is possible that these people, they have the rights to file, they have right to file appeal towards any order which is being made. So Mr. Mallya, he exercised that power and he has filed an appeal. So that appeal was heard in April 2020 and it was quashed by the court. They stated this appeal is unwanted and your extradition order is still intact. And then in 2021, Mr. Mallya again filed an appeal. He wanted appeal with a higher court and he wanted to know the ways in which he can continue staying in the UK. So he doesn't want to come in India definitely because he knows he'll be punished here, and that's the reason why he doesn't want to come to India, and he is wasting time there by filing different appeals. So he's filing appeals and the court there, which is equivalent to the level of Supreme Court in the UK, they've stated that the extradition of this person is pending because some confidential legal issue is going on with respect to that person. Some confidential issue is going on with respect to that person, and unless that legal issue is completed, we cannot send him back to India. And that is the reason why the extradition is still pending. And talking of Nirav Modi, as we've already discussed, so his advocate stated that he is at high risk of suicide, and that is the reason why he is not being sent to India till now. So though there are agreements made between countries to make the entire process easier, so India and UK, they entered into an extradition treaty in 1992. So India-UK extradition treaty dates back to 1992, wherein all the rules and regulations for extradition of a person from one country to another country were made. So it is not that people only flee from India and take resort or take shelter in some other country, but people from other country also come to India to take shelter here. But yes, though the number of people going from India or fleeing from India is more, but that's where these agreements which are made between the foreign countries, they come into play, and the countries, they'll have to together sort out the issue. And wherein so many agreements have been made, so many treaties have been made between India and different countries, they are made with an intention to make the process even more smoother, and also with an intention that both the countries are not at any loss. So though there are many agreements in place, though there are many treaties in place, still there are a few people who are not surrendered to India yet, because the laws of those countries should also be abided by, and till the time that country is not satisfied, they do not send or they do not surrender the people back to India. And that is the reason why it takes a long time. And if it is a tax haven country, if it is a country with which India does not have any treaty, then there is no situation, or rather then it becomes very difficult for the Indian government or Indian officials to bring that person back to India. Let's now start with section 57, which talks of letter of request to a contracting state. So let's now understand this section with help of an example. Now say Mr. Mallya, he has taken shelter in the UK and he is there in the UK. But the case against him is still going on here in India, and the investigating officers are still investigating his case. Now what happens is, the investigating officer here in India wants an evidence, and they are of the opinion that we can find this evidence in the UK. Now these investigating officers, they approach the special court. They approach the special court and inform the special court that some proceedings are going on and we require an evidence for these proceedings. And we are of the opinion that we will surely be able to find the evidence there in the other country. So The investigating officers cannot book a flight, directly fly to London and start doing their investigation there. They'll have to approach the special court. They'll go to the special court, inform the special court that these proceedings are going on against this person, and we know that we can gather some evidence from that other country. Now, in this situation, it is the special courts who will have to check into the matter. Now, special courts, they'll not directly send a request to the other country that my investigating officers are of the opinion that you have some evidence. No. Special courts will first satisfy itself, and on being satisfied, the special court will write a letter of request to a competent court or competent authority of that other country. Now, say the special court in India, they are satisfied that whatever investigating officers are stating that Mr. Mallya, we can find evidence against Mr. Mallya there in the UK is correct. Now the special courts here in India will make a request with a competent court or with a competent authority in the UK. Now the name of the authority in the UK will not necessarily be a special court. So it has to be a competent authority, an authority which is in a position to comply with the request of the special court. So special courts will now make a request to the competent authority there in that other country and request them to send the evidence here in India for the purpose of the investigation or for the purpose of the proceedings which are going on. So what is the flow? First, the investigating officers, they are of the opinion that we will find evidence there. Now these investigating officers, they go to the special court. Now special courts, on being satisfied that there is a surety that we will find evidence there, they will write a letter of request to a competent authority in the other state, in the other country, in the other contracting state, and from there then this contracting state will then send evidence here to the special courts. So this is how the flow goes on. And section 57 talks of the letter of request. So in a situation wherein say an offence has been committed in India, but the person resides outside India and the investigating officers are of the opinion that they will be able to find evidence against that person in that other country, then the investigating officers can approach the special court. Who can make the request? It is the special court who can make the request with the other competent authority of that other country, and the evidence, where is the evidence? The evidence is in other country, and from that other country the evidence is then sent to India. So this is how a letter of request can be sent in order to obtain some evidence from some other country or from some other contracting state. Now when the special courts, they are making a request with the contracting state or the competent authority in the contracting state, they may specify certain things in the letter of request. Firstly, they would ask the competent authority to examine the situation and the facts of the case which is subject to investigation. Then they may also state certain reasonable steps to be taken by these authorities in the letter of request. So when the letter of request is being sent by the special court to the competent authority in the other country, they will ask the competent authority in the other country to examine the facts and circumstances of the case and also take reasonable steps as the special court specifies in the letter of request, and they may request the other contracting state to forward all the evidences which they receive during the course of investigation or during the course of examination of the facts or circumstances. Whatever evidence this competent authority of other contracting state has received, they shall then forward all the information to the special courts, and then the special courts will act accordingly. So first, an investigation is going on a person where the offence has been committed in India, but the person is say outside India. Now in this situation, the investigating officers or any officer of superior rank, they are of the opinion that the evidence, they will find an evidence in the other country. So they will approach the special courts. Now special courts, on being satisfied that the claim which is being made by the investigating officers is correct or is valid, they may write a letter of request to the competent authority in that other contracting state. Now this letter of request will state a few things as to they'll request the other contracting state to examine the facts and circumstances of the case, and also take reasonable steps as may be specified by the special courts, and finally forward all the information, all the evidences which they have received during the course of inspection or investigation to this special court. So all the information will be transferred by the competent authority of other contracting state to the special court. Now, what is the mode in which the transfer of information or evidence will be made? The mode of transfer will be specified by the government. The mode of making the request will also be specified by the central government. So, as specified by the central government, in the similar manner, the request shall be made by the special courts to any person, to any competent authority of the other contracting state. So, section 57 talks of letter of request to other contracting state. So, what does it say? If in the course of an investigation into an offence or other proceedings under this Act, an application is made to a special court by the investigating officer or any officer of superior rank to the investigating officer that any evidence is required in connection with investigation into an offence or proceeding under this Act. So, an investigating officer or any superior officer, they are making an application with a special court that they require some evidence for the investigation or for the proceedings, and he is of the opinion that such evidence may be available in a place in a contracting state. So, and they are of the opinion that this evidence shall be available in the contracting state, and the special court, on being satisfied that such evidence is required in connection of the investigation into an offence or proceedings under this Act, what will the special court do? They will write a letter of request. They may issue a letter of request to a court or authority in the contracting state competent to deal with such request, to examine facts and circumstances of the case, take such steps as special court may specify in such letter of request, and forward all the evidence so taken or collected to the special court issuing letter of request. So, let's understand the flow once again. So, what is happening here? An investigating officer is investing a case, and that investigating officer is making an application to a special court. And do you think special court will just look at the application and make a letter of request? No. Special court will first satisfy themselves that this evidence is actually required for the purpose of investigation, and only once they are satisfied, they will make a letter of request to other contracting state. So what is happening? An investigating officer is carrying on an investigating officer is carrying on an investigation. He requires some evidence and is of the opinion that this evidence will be available at a contracting state. So, when the investigating officer is of such opinion, he will make an application to the special court with all the facts of the investigation and the proceedings. Now, special court, on being satisfied with what? On being satisfied that this information or this evidence is actually required for the proceedings, the special court will issue a letter of request. Now, to whom the letter of request is issued? To either a court or any competent authority in the contracting state. And what are the things which will be stated in the letter of request? They will request them to examine the facts and circumstances. Apart from it, they may ask them to take some reasonable steps. as may be specified by the special court in the letter of request, and then finally forward all the evidence received. So the special courts, they may issue a letter of request to that other contracting state, wherein they will ask them to examine the facts and circumstances of the case, take some steps as specified by the special court in the letter of request, and also forward all the evidences which they have collected during the course of their investigation or inspection, and forward every information collected to the special court. Now let's look at the mode of issuing a letter of request. So what is the mode of communication of letter of request? The letter of request shall be transmitted in such manner as prescribed by the central government. So as specified by the central government, the letter of request shall be issued in that manner. Talking of nature of evidence, so every statement recorded or document or thing received shall be deemed to be evidence collected during the course of investigation. So every statement, document or any other thing which is received by the special court shall be deemed to be evidence for the purpose of the investigation.